are in listen-only mode.
Hello everyone, this is Ryan Thurman here with Contact Center Compliance, and today I've got Andrew Cove with Cove & Associates to talk about how to survive when the regulators come knocking on your door, some real-life examples from a former federal prosecutor in the Economic Division at the Florida AG's office, sorry, not federal prosecutor.
State prosecutor.
State prosecutor. And so Andy's got some real insight from coming from working in the former enforcement agency to representing some of the larger cases involving FTC and FCC enforcement, state enforcement. I first met Andy quite a while back at a compliance seminar, and we share a lot of clients in common from time to time. And so we thought we'd put together some really, I think, insightful information on what actually happens when you get investigated, what kind of defenses you can use, and what to expect, and what you should really be doing to kind of stay out of that boat. And so we're going to spend about an hour today talking about some of these things that Andy has experienced, and he's got a really interesting slide deck, so I think you guys are really going to get a lot out of this presentation. Just a couple quick housekeeping things. We do have the slides available. There's not a whole lot of detail on the slides, but if you'd like them, we can get you a copy after the presentation, as well as the actual webinar itself. The audio is being recorded, so we'll have that available. We have a little channel on YouTube that I can get you guys the link to, so we'll deal with that later. But for now, I'm going to hand it over to Andy, and we're going to jump into some of the presentation points just because we've got a limited time and there's a lot of great material. So, Andy, thanks for joining us today.
Thank you, Ryan. Thank you. And I want to say good afternoon to everyone. Today, give me the next slide, too. Today we're going to primarily talk about how to manage conflict. At most of these seminars and webinars that we all attend, we hear a lot lately about how to comply with the TSR and how to comply with the other laws and rules that apply to telemarketers, and rightly so, of course. But today we're going to talk about an entirely different side of things, which is what happens when things have already gone wrong, how do investigations and lawsuits typically unfold, and how to best handle that challenge. So at the end of this hour, I'm hoping to at least first simply educate everyone a little bit about the litigation side of our system and what to expect, and two, suggest some possible preparatory steps, aside from compliance itself, which of course is the very first preparatory step that we should all be taking. Before I go on, let me make the obligatory lawyer's caveat. I'm keeping this presentation very simple on purpose and very general on purpose. I'm hesitant, of course, at least in this setting, to give any specific legal advice about your situation. Obviously, every company and every situation has very, very specific facts and circumstances. So if you have legal questions, direct them to your own attorneys if you have them, or find a good attorney to fully advise you. Okay? So let's move on to the next slide. Ryan, please. So the first thing we're going to talk about is the environment out there. Who are the enforcement agencies that are our typical adversaries? And I use that term respectfully, but they are our adversaries in this context. First and foremost, there's the Federal Trade Commission, which is the main federal agency responsible for oversight of telemarketers and telemarketing fraud. And of course, they're also, these days, responsible for oversight of the various rules within the TSR and so forth. They are the primary agency that lawyers like myself have to deal with in defending telemarketers. Secondly, we've got state attorney general's offices, and they're analogous to the Federal Trade Commission. In other words, they're just a smaller version of that same agency. In fact, the laws that they administer are usually modeled directly on the FTC Act, the main FTC Act. and they have often modeled their DNC and other rules after the federal the Trade Commission's rules. Another interesting point is that the State Attorney General's offices, just like people, they have sort of personalities, and some of them are tougher, some of them are more difficult, some of them are less tough and less difficult. Some of them even have sort of areas of expertise or areas that they emphasize. These personalities don't always comport with their size, or like the Californias and the New Yorks are not always tougher than the Wisconsins and the Indianas, and sometimes it's the opposite. So they all have sort of a personality that apply, and that too is sort of an area in which experienced compliance officers and experienced lawyers who deal with these people can give you a little bit of an edge, because they know who's who and who the tougher states are and who the tougher agencies are. So first, we've got the Federal Trade Commission. Second, we've got the State Attorney General's offices. Third, we've got the Department of Justice, and that's the U.S. Attorney's Office, also known as the U.S. Attorney's Office. Sometimes on civil cases, they join with the FTC in telemarketing-related prosecutions, usually the more serious telemarketing-related prosecutions for fraud. They also, unlike the Federal Trade Commission, the State Attorney General's offices, which primarily are civil agencies, and maybe we'll touch on the difference in a moment, but they primarily sue companies and individuals for money more than punishment reasons. Unlike those agencies, the Department of Justice does both civil and criminal cases. Different departments, but within the same Department of Justice, they do both. So on the civil side, they sometimes join the FTC and become adversaries to our telemarketer clients. On the criminal side, they sometimes also bring action, a criminal prosecution. Although criminal prosecutions obviously is not an issue that applies to the vast majority of the people listening and the vast majority of telemarketers operating out there, thankfully. But criminal prosecution has become more and more prevalent in telemarketing world. So it's something worth mentioning, it's worth noting. And then finally, D, the final point on this slide, is other agencies, sort of the miscellaneous category. We've got local, state, county, and city consumer protection agencies, which differ from state to state and county to county and so forth. We've got local law enforcement, just police departments, which sometimes pop into the scene for one reason or another. We've got Better Business Bureaus, which are not technically governmental agencies. They're really a private business or a private franchise. They do become adversaries on occasion as well. What I didn't add to this slide, which I should mention as well, is lately individual consumers, and I shouldn't even say lately, it's something that's existed for a long time. Individual consumers out there sometimes bring action against telemarketers, whether formal or informal. They often start, of course, informally with a letter or demand letter. But individual consumers, there's sort of an underground out there. These cases are not usually fraud cases, but they're still problematic. There's a little underground out there that sort of makes it a little business to go after telemarketers for usually the less serious types of violations, things, lead generation issues such as DNC, robodialing. In the old days, they used to sue and make demands related to fax blasting. But nowadays, it's mostly DNC and robodialing, and they're small nuisance-type cases, but they're still problematic, and partly for that very reason. There's sort of a paradox there. They're small, and $10,000 claims, let's say, but some of these people are very knowledgeable. They create a lot of, they make a lot of noise on the internet. They'll sue a marketer from sometimes across the country. And when you're being sued for $10,000 across the country, there's not a lot of value in defending it, even if you're in the right. So they're nuisance cases, and they're a pain in the butt to resolve. But fundamentally, they're all about money, and it's galling. But they too have become sort of regular adversaries. In fact, there's a club. Like I say, there's a club of these people, and I've seen some of them 15 and 20 times now over the last 10, 15 years. So they keep popping up.
What about the
next slide, please.
What about the Andy? Sorry to interrupt, but we got a question on the
Sure.
on the enforcement agency that we don't have the FCC listed.
They're not all that active, frankly, on the litigation side. There's been talk from them about getting more and more involved in these cases, but the truth is they've been relatively quiet in comparison to these other agencies I've listed. So occasionally we'll get a citation from the FCC, but generally speaking, we don't actually step outside and go to battle with them much at all. I can't think of any cases in which we've really had full-blown litigation. There are some agencies that I haven't listed here that we occasionally do battle with, and the FCC, in a manner of speaking, is one of them. Like I say, it's maybe not full-blown formal litigation, but there are citations, there are negotiations, and so forth. There are other agencies I haven't listed here, like the U.S. Postal Service. They have a postal inspector that's very active when it comes to mail fraud issues. But what I've listed here are the main adversaries we deal with on a day-to-day basis, at least in my office. But that is a good question. There are others. This is not a comprehensive list, but it's meant to touch on most of our typical cases.
Yeah, just to clarify for somebody else that had a question, I mean, we're really trying to gear this presentation, or it's geared towards telemarketing, outbound calling related issues. Some of this I may cross over to collections a little bit into some other calling areas, but it's primarily for folks that are dealing with the sale of goods or services over the phone, just to
Right.
give people some context so they don't think they're waiting for something at the big bang at the end. But we're ready to move on to the next slide.
Yeah, the presentation is necessarily a little bit general, but we do deal with very specific little sub-industries within telemarketing world. So we have sellers of travel and sellers of business opportunities, and the miscellaneous group of telemarketers that sell credit cards and debt consolidation and all kinds of things. So if you have specific questions, I'll be happy to entertain them. Not necessarily here in public, but if anybody has any questions, they're free to give me a call. I'll be happy to try to answer them in a private setting.
We will have some time at the end too for questions. So feel free to put those into the GoToMeeting toolbar. There's like a text entry, and we'll be able to highlight things as we go along that maybe need a little more clarification. But ultimately, we'll try to leave the rest of the questions till the end. We should have some time.
Okay. So the next slide, how and why investigations are triggered. And we're not talking about topical or anything else. We're just talking about, well, what makes an agency pick on a particular company or focus on a particular company. In my experience, it's usually one of these three things. The last one is topics of particular interest, but the first is a large number of complaints just generally, and that applies even if they're relatively innocent, innocuous complaints. Numbers do matter. If your customer service department is doing a poor job, and for whatever reason people are filing complaints and making calls to these agencies, there is a certain critical mass that is sometimes reached. So a lot of cases are triggered by nothing more than numbers, especially if it's a low price point kind of a product and high volume kind of product. The second is sort of the converse, not necessarily large numbers, but really ugly complaints, really nasty sounding complaints, whether fraud or otherwise. And one of the considerations on the part of these agencies, rightly so, I guess, is who the complainants are. If there's a lot of elderly people complaining, then that'll get their attention. And then finally, there are topical issues. There are, in other words, certain things are hot at any particular time. I've been doing this about 25 years on the defense side after I was a prosecutor, and over the years there have been constant changes in what's hot and what's not, and it changes every year or two. There's travel, there's metals, there's foreign exchange options, all kinds of things become hot at any particular time, only to go down in flames eventually because of market forces or other issues. So for the moment, I put in my examples for the moment. I've had a lot of timeshare resale companies, the companies that are trying to market timeshares. I've had a lot of debt reduction companies. I've had a lot of cases involving robocalls lately. And these issues, and I'm probably not thinking of a few others, these are hot topics for the moment. And that too, if a particular state agency or federal agency is sort of on the lookout for debt reduction companies, they'll pull that out of their list and give it particular attention naturally. So, so that's how and why investigations are triggered. Next slide, please, Ryan. Then we've got classes of violations. This is sort of my hierarchy, if you want to call it that, a hierarchy of trouble, from worst to not so bad. Fraud-related claims, of course, are the very worst types of claims. Essentially, fraud implies that there were misrepresentations made. So non-delivery, non-fulfillment, failure to refund, charging without authorization, all those things imply a lie of some sort, a misrepresentation of some sort. And of course, that's far worse. It's common sense to probably anybody that's much more serious than simply, robocalling. When you may have a perfectly legitimate product and service, but you're robocalling, your lead generation is in some way flawed. According to the law, fraud-related claims are much more serious. And fraud cases have a very broad reach. For that very reason, they're more serious claims. So significant assistance to someone committing fraud, like a processor or a broker, will sometimes be attacked by the authorities as well, because they are giving significant assistance to someone who is a wrongdoer, a Madoff, let's say. And if you're a vendor to somebody like Mr. Madoff, and you know or should know, because the signs are very obvious, that you're assisting someone who's committing fraud, it's not considered acceptable in the legal world to just kind of look the other way. And so those people can be prosecuted directly, both criminally and civilly. So that's my first class of violation. It's the worst case in the hierarchy of trouble. Secondly, we've got lead generation issues, which are less serious than fraud cases, of course, but very, very commonplace these days. We're seeing a lot of DNC-related cases and voice broadcast, robo-dialing cases. We had a case last year, a couple of years ago, where a dialer company paid $1 million to settle a pure DNC case. And it's a lot of money, and it wasn't such a big company either. And then the third category is licensing violations. Here in Florida and many other states, they have telemarketing registration requirements, telemarketing licensing requirements. And that's kind of become a hot topic in certain states, including Florida, for example, my home state. This morning, I was on the phone for a couple of hours dealing with a licensing agency that popped in on a new client. They weren't my client until today, but they popped in on somebody, and they're fining them $51,000, and that's the settlement. It was $198,000, purely for not having licenses in place. The regulators tell me, wow, it's a beautiful call center. Everything's being done very well. Everybody's respectful. The product is an awesome product. But because they're not licensed, it's a $51,000 hit. So licensing cases can be an issue, at least monetarily they can be an issue. So that's my hierarchy of violations, or hierarchy of trouble. Next slide, please. Now, and actually before I get into civil enforcement actions, I'm realizing maybe we should talk briefly about the difference between civil and criminal actions. There's actually two kind of divisions in the legal world. And a lot of you out there probably know this, but just to be crystal clear, civil and criminal cases represent the two parts of our justice system. Civil cases generally imply a claim by, whether it's an agency or a private party, a claim for money, a claim for civil relief, It's not about punishing you necessarily, although that is one of the effects sometimes. It's about compensation for some kind of wrongdoing, but a civil wrongdoing. Criminal cases, by contrast, are always brought by the government, never by private parties. And the idea in a criminal case, at least in a general theoretical way, it's about punishing someone for committing wrongdoing. Those two things are very different. They have, in some cases, different courts and different systems and different agencies, as we've discussed briefly. So that's the first way in which our system is divided. It's divided in sort of two halves, civil and criminal. The second way that our system is divided is something I also alluded to earlier, which is the federal system and the state system. Federal agencies and federal cases involve claims that involve crossing state lines. That's what makes something federal in a very general way. And state-related cases are cases in which the wrongdoing or the issue is something contained within the state. So state AGs are only interested in cases, or can only pursue cases, in which, let's say in our example, a telemarketer is selling from their state or to their state. If a telemarketer is selling from Georgia to Alabama, then the Florida AG's office has no business poking their nose into it. But by contrast, the Federal Trade Commission does have an interest in poking their nose into it. It crosses state lines, and if it's interesting enough to them, big enough for them, they will bring what is a federal case against the wrongdoer. So civil enforcement actions on this slide refers to sort of the most commonplace types of actions that are brought against telemarketers. They are usually civil. In what I just discussed was the difference between civil and criminal. Most of the telemarketing related cases I see are civil. I'm mostly a civil lawyer, and most cases in this arena are civil. So civil enforcement actions relates to both federal and criminal cases, but whether you're being pursued or investigated or sued by the Federal Trade Commission or the AG's offices, these civil enforcement actions have sort of a common protocol. Often they start with a subpoena for information or civil investigative demand, which is pretty much the same thing. It's a request for documents and other information that is usually issued in writing, always issued in writing. It can be very, very comprehensive. In other words, it can be very detailed. It'll ask just about everything that the company does and who's involved and what the product is, and copies of scripts and sometimes copies of bank records and so forth. So it's very invasive. When the FTC issues one of these, there's not a whole lot a company can do to avoid responding. When an AG issues one of these, especially if it's a foreign AG, let's say an Indiana AG issues a subpoena to a Florida company or a CID to a Florida company, there are some jurisdictional issues. There is again, I don't want to give legal advice, but there's certainly a question there about whether Indiana's AG has any power to issue a subpoena to a foreign state entity. But I'll leave that to your counsel, and every case is different, of course, but the bottom line is it's a catch-22. Responding is bad because it often gives the AG or the FTC information with which they will hurt you. But not responding is bad too. It'll irritate, obviously. It'll aggravate the issuing agency, and even if you can legally get away with it, it's not always a smart thing to do. So getting one of these subpoenas or CIDs is a signal that you've got a problem. Depending on what your company does and how it does it and how clean it is, it may or may not be all that serious ultimately, but it's always bad news, of course. And cases don't always start with a subpoena or a CID. Sometimes they do when the agency still sort of needs to gather more information to sue, or when they're maybe just thinking about whether they should pursue something formal. But they do sometimes start with a CID or a subpoena. then if they do file a formal action, the FTC routinely, and AG's offices perhaps a little less routinely, when they file the lawsuit, they'll file a complaint, which is a normal lawsuit, but they will also often file requesting an injunction, an ex parte temporary restraining order, which is essentially an injunction is just a court order requiring you to do something or preventing you from doing something. So an ex parte TRO is a particular type of injunction. Ex parte refers to the fact that it's without notice to the defendants. And TRO is a term of art that really, in a way, can be explained by saying it's a very short-term injunction. In federal court, TROs are usually good for 15 days, up to 15 days. Ex parte TROs are given without notice to the other side. So essentially, the FTC, let's say, in my example, will file a lawsuit asking for restitution and so forth in a more or less normal way, but at the same time they'll file a request, a petition for an ex parte TRO. And they'll do it without giving the other side notice, without having served the defendants at all. They'll go upstairs to the judge's office and essentially tell the judge, with affidavits only, not even real testimony, they'll essentially argue that it's important because these people are committing fraud or what have you, to freeze their assets, very typical, or appoint a receiver, very typical, take possession of the premises. All these things, very typical things for the FTC to request without notice to the defendants. So it's pretty devastating. And ultimately, they'll come to the defendant's door with a big box containing a brand new lawsuit and an ex parte TRO, which essentially, as I say, will tell the defendants and the individual defendants, individual principals, that, you know, guess what? All your assets are frozen. You can't go to your ATM. You can't touch your own money. And wherever it is, whether we know about where it is or not, you can't touch your money. You can't even use money to hire a lawyer. So in FTC world, that's very common, and I'm sure you can imagine very difficult to deal with, a very difficult challenge. Even getting a lawyer requires you to go to family and friends and scrounge up what, in this kind of case, is not so little, not such a small retainer, tens of thousands of dollars at least. So these cases often start with an injunction side by side with the lawsuit itself. Now, the term preliminary injunction that you see there is really the same kind of order, the same kind of injunction as an ex parte TRO, but for due process reasons, what happens is the ex parte TRO is very short term, as I say. The judge will usually enter it upon request by the FTC and give the FTC, say, a hearing date 10 days out, sometimes even 5 or 6 or 7 days out only. And that hearing is called a preliminary injunction hearing. The idea is to turn that TRO, which is given with no notice, into a more long-term injunction, which is given with notice. Not much notice, but with notice. And so that hearing is intended to give the defendant a chance to say whatever they've got to say. Very, very, very often, the vast majority of cases, the ex parte TRO very smoothly gets rubber stamped and turned into the preliminary injunction. It's very hard, as you can imagine, to effectively defend yourself with say, a week's notice, especially when the ex parte TRO often is accompanied by a stranger, a receiver, taking possession of your premises. So the preliminary injunction is good until, basically indefinitely, usually until the end of the case. And so these injunctions are worth mentioning at least. So that's sort of a sideline. That's sort of a detour to the main case, but a very important detour, at least at the beginning of these cases. C refers to basic civil procedure. How does the case itself, the case in chief, the main case, aside from the injunction, proceed? Well, it proceeds in a pretty normal way. That part is not abnormal like the injunction is. You've got pleading stage, and this is very, sort of, I'm keeping it very simple. Pleading stage is essentially the complaint, the answer to the complaint. The pleadings, there's a rebuttal of that, but basically the pleadings are the very first stage in which each side tells the court what they want or what their defenses are, and that's the pleading stage. And by the way, these stages, as I've written them out, they do overlap quite a lot. So just because discovery is after pleadings doesn't mean it's neatly after pleadings. The beginning of discovery is sometimes almost immediately. Discovery is how lawyers do their homework. We are in America, both state and federal cases, we have what we call very liberal discovery rules, meaning in my little example, the FTC can ask the defendants to produce papers, answers to questions, they can take depositions, they can ask them to admit or deny certain specific facts. Discovery refers to getting information from the other side or from third parties. And the defendants have those very same rights. So a little bit like the subpoena, pretrial subpoena. Discovery is a way to find out what the other side has and who the other side's witnesses are and what they're going to say and so forth in advance of trial. We have a very, very open, very liberal discovery rules, so there's not a lot of limitations on that generally. The third stage is mediation or settlement. Mediation is a sort of formal settlement conference with a third party, a mediator, who is hired to sort of referee the discussion. Settlement in general is just settlement in general. Lawyers do speak to each other, adversaries speak to each other routinely about settlement, sometimes very early in the case, sometimes not. There's no rule for when you can talk about settlement. Sometimes it happens on the very eve of trial, but that's the third stage. Mediation is required in most courts nowadays. A formal mediation is required. But in my experience, these kinds of cases don't often settle through a formal mediation. They usually settle with the informal settlement discussions, partly because these cases are a little bit esoteric, meaning they're unusual, they're different, there's not a lot of expertise out there, and the mediators often don't have a clue what we're talking about when we go to mediation, so it's almost easier to talk directly to the FTC or to the AGs. And then ultimately, if mediation fails and settlement fails and there's just no meeting of the minds, you have a trial. It's just like any other kind of trial. In this subject area, trials are typically non-jury trials. There are some exceptions, but in civil enforcement actions generally, we've got non-jury trials in these kinds of cases. D, Fifth Amendment issues. I'm referring to the Fifth Amendment here because it does come into play sometimes. The Fifth Amendment, for those of us who don't know, when we all watch TV, we see that on Law and Order, defendants sometimes assert their Fifth Amendment privilege, as we say. The Fifth Amendment basically says that you're not required to give answers to questions when those answers might incriminate you, might help the authorities incriminate you. So you're not required to admit you committed a crime, and you're not required to admit anything that helps them, helps the authorities put their case together. But it only applies to cases in which the answer is going to incriminate you, not civil cases. So unfortunately, in very serious telemarketing-related fraud cases, this is something we have to consider. You essentially, to walk you through how this works, if I have a defendant, let's say Bernie Madoff, to use a good example that everyone knows. If Bernie Madoff walks into my office and he tells me that he's been sued by the SEC or the FTC, and they want to question him, and it's crystal clear that the answers to those questions are going to incriminate him, then we have to probably assert his Fifth Amendment privilege and refuse to answer their questions, just like you see on TV sometimes. Now, in a criminal case, when the police department questions you, and that's all we're looking at is a criminal case, there's no real downside, in a way, there's no real downside to taking your Fifth Amendment privilege and asserting it. The judge is not allowed to comment on it. The prosecutor is not allowed to comment on it. The jury is not allowed to hear about it. If you refuse to even testify, that's perfectly acceptable. That's part of the Fifth Amendment privilege. And they're not allowed to mention it to anyone. They're not allowed to use it against you. But in a civil case, they are. So in the way it plays out is if Bernie Madoff is my client and we're looking at strictly a civil case, but I know that his answers might, put a criminal case together, might lead to a criminal prosecutor, making charges against my client, filing charges against my client, then I'll sometimes have a difficult decision. If he asserts his Fifth Amendment privilege, that's a good thing. It helps us, keep certain things quiet. But it's a bad thing on the civil side because they are allowed, unlike in a criminal case, they are allowed to use that assertion of the Fifth Amendment against my client. We call it drawing an adverse inference. So the judge is allowed, essentially, he's allowed to assume that the answers to the questions, the answers to, let's say, the complaint itself, or the answers to interrogatories, written questions in discovery, or the answers to deposition questions that are all, when there's a refusal to answer those things under the Fifth Amendment, he's allowed to draw an adverse inference. He's allowed to use it against my client. He's allowed, essentially, to say to himself and out loud that he's allowed to assume that the answers would have been harmful to my client. So taking the Fifth Amendment is not something you do with impunity. You really have to think it through. It's like a big chess game. Sometimes it's the right thing to do. It's especially the right thing to do if you expect, if you know that your client's done something really awful and it's obvious that he may be charged criminally later on. And especially, it really comes in handy when you know that the crime itself cannot be proven without your own client admitting it. Sometimes crimes are not easy to prove. So the Fifth Amendment is an issue that comes up in telemarketing fraud cases, the bigger ones, routinely. Won't apply to most of you out there, and won't apply to robocalling cases or DNC cases, but it applies to the sort of the sexiest, biggest, ugliest cases that we get. E-resolution is a whole topic in and of itself. In civil enforcement actions, whether with the FTC or the AG's offices, they have sort of a protocol. They're predictable. They like to do things in a formulaic way. And so the way these cases are usually resolved, if they're resolved at all, and they usually are, the way they're resolved typically requires you to agree to a consent order in which contains a few things that I've listed here. There's typically one, a permanent injunction, a permanent agreement that you won't do the bad stuff that you were doing as far as they're concerned. So if you were selling debt reduction services and they think you were doing it in a way that was inappropriate, you'll agree, commonly, you'll agree to a permanent ban on being involved in debt reduction services. Sometimes they think you're such a dangerous marketer that they'll ask for a ban from telemarketing, period. They don't want you to be a telemarketer for any product or service. So there's usually, one, a permanent injunction of some sort. Two, there's the money issue. And the money issue is dealt with in a very unusual way as well. In these cases, the FTC and the AG, for that matter, they're analogs. They're almost exact copies of each other for the most part. In general, they're suing a client, a telemarketer, who's committed wrongdoing. They're usually suing them for every penny that they ever took in from day one. Top line gross receipts. So if the company took in $10 million, and it doesn't matter And naturally, that $10 million does not represent profit in any way, shape, or form. But that is what they technically can and do sue you for. And they sue the individual principals. I haven't touched on that at all, really, but in FTC cases and AG cases, and for that matter, almost all these less serious cases involving voice broadcast or DNC or what have you, any kind of consumer protection case, you don't have the usual normal protection of your corporate veil, what lawyers call a corporate veil. You're sued personally. In addition to your company being sued, it's normal in my world to have my clients sued personally for everything they've got sometimes. So in an FTC case, in a typical FTC case, they're suing my client who did maybe $10 million in business. They're suing her for $10 million, and they're suing, Bob Jones, the principal, for the same $10 million personally. If everything he now has is, let's say, $1 million in assets, then it's very common to settle the case for, let's say, I'm picking numbers out of my head, it's very common to settle the case for the majority of what he's got left, let's say $800,000. And it's very common in that example, if the FTC is satisfied that that's all there is, and that this is a satisfactory payment under these circumstances, it's very common for them to put into the consent order that you're agreeing to a $10 million judgment, Mr. Jones and his company, Mr. Jones individually and his company. But the other $9,200,000 is suspended, which means it's just kind of put aside. It's unofficial. It won't be collected. Why do they bother putting that in there? Because it's suspended but can be unsuspended under certain circumstances. So they always have something called an Avalanche Clause in these cases, in which basically says, in my example, Mr. Jones will pay $800,000, and the remainder, the $9,200,000, will be suspended unless, and we're relying on his financial statements because he fills out financials and establishes what his assets and liabilities are and so forth. That $9.2 million is suspended unless we discover that he made a material misrepresentation, that he lied in a material and an important way. So if they discover $50,000 is socked away in Monte Carlo somewhere, and they discover it even years later, and they put two and two together, and they realize Jones lied to them back in 2012, they can unsuspend the judgment and go after him for the full $9.2 million, not just the $50,000, but now the full $9.2 million is active. It's alive. It's a real judgment. So that's what an Avalanche Clause refers to. And that name is used, obviously, for the dramatic effect. But it is the vernacular. It is the code that is usually used. And so you've got the permanent injunction, you've got the suspended judgment with some payment, and an Avalanche Clause. And then finally you've got fencing in provisions, which are typical in both FTC world and the AGs. Fencing in provisions refers to provisions that typically require the defendant to let the FTC, the agency, know whenever he's changed jobs, whenever he's changed his residence, whenever he's started a new company. The idea of fencing in provisions is, let's keep tabs on this guy. That's part of the agreement, is you're going to let us keep tabs on you. You only have to tell us when you change something. And actually, let me back up. Usually what's required is, and they do things, as I say, in a very formulaic way, a very consistent way, generally. These things may change over the course of years, but they're very consistent from case to case. My FTC cases, and I've had a lot of them, always contain these various ingredients. So it's typical for fencing in provisions that you're required 6 months after you settle your case, you have to fill out, or you have to send in a baseline report. Here's where I live, here's where I work, here's what I do, blah, blah, blah. That's the only one that's mandatory. After that 180-day report, it's just about sending in changes, just amendments. You never, if you don't move and you don't change jobs and you don't change anything else in your life, 20 years might go by or 10 years might go by. If you do change something, you're required to send something in and let them know. Otherwise, you violated your consent order. That does not trigger the Avalanche Clause, but you have violated your order and you can be sued or prosecuted for contempt. So fencing in provisions are always part of these agreements as well. They used to only request fencing in provisions for 3, 5, 6, 7 years. Now lately they've been asking for as much as 20 years. I was recently asked for on a case, although we didn't agree to it. So so that's the story with civil enforcement actions. This applies to both FTC cases and AG cases, but particularly to FTC cases. They're very consistent. The AG's offices, there are 50 of them, of course, and they do differ a little bit from state to state. So some of them use injunctions routinely, some of them don't. Some of them use some of these other, some of them take some of these other steps, some of them don't. But these examples all apply to FTC cases at the very least. So next slide, please, Ryan.
Cool. We're on to criminal prosecution.
Yep. So the other kind of case, as I said earlier, our system, is divided into two parts, civil and criminal. My cases are normally civil, 90% of them, but there are some unfortunates that have committed wrongdoing on a very large scale, like the Madoff example. Not my client, of course, but I've unfortunately had, not unfortunately for me, but unfortunately for my clients, some of them have been sort of notorious and have been prosecuted criminally. When the government files a criminal prosecution, if it's a very significant case, and if it's any telemarketing case involves crossing state lines, typically, not necessarily, but typically, of course, they cross state lines. So our main adversary on the criminal side are the U.S. Attorney's Office, also known as the Department of Justice. So these are federal cases. Federal criminal cases are very, very serious. Unfortunately, they have extremely long sentences for things like telemarketing fraud. White-collar crime is not punished lightly like it used to be when I was a young man. And typically, the charges that are brought for telemarketing-related fraud are mail fraud, the use of the mails to commit fraud, wire fraud, the use of the telephone to commit fraud, money laundering, which is essentially using ill-gotten gains to do anything. Buy a car with stolen money, it's money laundering. And licensing violations can be criminal too, although they're far, far less serious than sort of the fraud example I'm using. As I say, the penalties are significant, and for telemarketing fraud, that's partly because on the federal side, both the number of victims, which is large in telemarketing typically, and the dollar amount involved, which is large in telemarketing typically, those two things are big, important factors in the advisory sentencing guidelines. So I've had clients and former clients and acquaintances sentenced to unbelievably long sentences. I had a client years ago, Kyle Komodo, who got 350 months for a purely business-related, purely telemarketing-related fraud case. That's 28 years. You do 85% of your time, come what may. That's the best-case scenario once you're sentenced. You can't get better unless the sentence is actually reduced at some point. But he's got a sentence of 28 years. He's going to do 24, and I've had many other examples of 20-plus year sentences. Not so many, not that I've represented them on their criminal cases, but people I know. And a recent former client who was selling timeshare resale just got sentenced to 15.5 years. Those numbers are not uncommon. You'd be better off being a gangbanger and shooting up a 7-Eleven than committing large-scale telemarketing fraud when it comes to sentencing. So the criminal prosecutions are a very small minority of what I see out there, but they're becoming, unfortunately, more and more and more common. State cases, too. I've got clients here in Florida, and I represent clients all over the country, but, of course, people come to me right here in Florida sometimes. I've had some criminally prosecuted for relatively minor things, but they're still criminal cases, not having a license. I've got 2 of them recently this last couple of weeks, and they're third-degree felonies, and they're going to be resolved relatively smoothly and without any jail time, but it's a tool that the authorities are using more and more. Criminal prosecution for these kinds of things used to be sort of unpopular with prosecutors, but now they're becoming more and more so. So that's about it. Let me talk briefly before I close about next steps or prevention steps for just a moment before I call it a day. As I said at the beginning, everybody's situation is different, and you know, a lot of my recommendations would be dependent on your specific facts and circumstances. But there are a couple of general rules that are kind of obvious. You know, document your good faith. Many of the applicable laws and rules, especially the lead generation, the DNC, robocall type provisions that most of you do have to be concerned about, some of you. Many of those sort of less serious issues that can still turn into a lot of money when you're prosecuted. Many of them have safe harbor exceptions which apply, and that means that if you're obviously trying to comply and you have a company policy in place and it comports with the TSR, and you're sort of doing everything correctly in general, and maybe you had a little oops, that good faith, that safe harbor exception it'll allow it to be considered. It'll allow your good faith to be considered, your policy to be considered. So document your compliance efforts, train your sales reps well, get help with scrubbing, have solid and crystal clear contracts in place whenever possible, discipline and fire non-compliant reps and vendors, have excellent customer service. That's a big one. A lot of these cases really arise from just bad management and bad customer service, because a good CS department will tamp down a lot of unsatisfied customers very quickly if they do it well and do it right. Have competent in-house compliance personnel. You know, larger companies now usually have a compliance department, and it's just essential these days. And of course, make sure you have good attorneys to review your protocol and to handle all legal issues when they do arise. And you know, there's a small group of us that does what I do. Some of us, like my office, do both compliance work and litigation. We're about 50-50, and then some people out there do just compliance or just litigation. But there are a few very good, very sharp lawyers doing this kind of work now, and it's important to have somebody at least that you can pick up the phone and call when you do have a problem. So I'll leave it at that, and thank you all for giving me the opportunity to speak with you.
Thanks, Andy. That was some great information. I really appreciate you joining us. There was just a couple of quick questions that were, I think, worthwhile mentioning. Before I do that, there are a couple free things that you can get just by having attended today's seminar. One is if you're looking at some of the changes with the FCC rules and you wanted to find out maybe potentially what your exposure would be with calling cell phones, we can basically scrub for cell phones, tell you, how many numbers you potentially might have that you might need to think about with customers, or maybe it might open your eyes to amount of customers that are actually using cell phone as their primary contact number. And we also do have a kind of a good step that you can take with safe harbor compliance. You can go through a safe harbor wizard with our tool, so I'll get some information out to everybody about that when we're done here this afternoon, along with a copy of the slides for the folks that want it, and then I'll also give you the link to the recorded version that I'll upload to our YouTube Contact Center Compliance channel. We also have a group on LinkedIn with people like compliance officers and attorneys and people that run call centers that kind of share ideas and post, news and stuff that's going on. That's worthwhile. There was 2 questions that I think we'll use, and then we'll wrap things up. One of them was, if you are in a situation where a one-off consumer is threatening suit under the TCPA and the state rules, one of the underground Andrew referenced, do you advocate having them sign a full release if you decide to settle the matter out of court?
I'm not sure if I followed. Is the question whether I would recommend having a general release when you settle?
Yeah, it says basically where a one-off consumer is threatening suit under TCPA or the state
Well, yeah.
rules.
When you settle any kind of case with a consumer or really anyone, you're going to want a general release. It's considered standard protocol in the legal world, and that applies even to the FTC or the AG or any agencies. You essentially get a release in a sense, because your agreement will always say this settles all matters between the parties up to today. And that's really all a general release is, with a private party too. And so yes, it would absolutely be standard procedure for me, and I think for any decent lawyer, to ask that plaintiff consumer for a general release before you hand them any money or make any deal.
And I get the question with those kind of people from our clients, how do we avoid these people? Do we put in good scrubbing practices? Yeah, that's a good idea. You have good documentation. Sure. You have a good attorney. What else can you do? Because they're playing a game knowing that it's going to cost you money to hire your attorney or get legal help to defend the case. And so, there's just...
That's exactly right. They make the cost of litigating, even when you sometimes have good defenses. I've got a couple now. With people I know well, the plaintiffs are people that just keep popping up year after year, and some of them are a little, I don't know what to call it, a little unusual. They're not always incompetent. Sometimes they know just enough to cause trouble, but some of them are a little unusual and sort of, difficult to deal with, to say the least. How to avoid them? It's a hard thing to do. I think the best thing I can think of is you got to share information about these particular sort of top 10 as much as possible, so that you never solicit them. You want to try to create your own list of your own internal DNC should include these people if you can, however you get their numbers.
Yeah, I know, and there's not like a national pool of them that you can go grab, and we've looked at developing that here, but they change their phone numbers all the time. They opt into different things, and so tracking...
They do, and they do. They actually get, there's a couple of them that look at this as a little business, and, it's kind of galling and annoying, but they look at it as a little business. In the old fax blasting days, we had one guy in Pittsburgh who had a bank of fax machines, rather, in his basement, just to sort of fish for marketers to attack. And I'm sure they do the same thing now with DNC and with voice broadcast. So it is a difficult thing to combat. I know that many of these guys, in this day and age, they talk to each other on the internet. They share information about you all. That's for sure. And I think it might be worth going on some of those sites and kind of fishing around yourself. They do often have their own phone numbers on there and their own information on there. And to a small degree, I guess, we could identify phone numbers and such, but it's not easy to do.
Yeah, definitely. Well, I appreciate your time, Andy. Hopefully we'll be able to do this again sometime, but I think there's definitely some take-homes for people. And it's pretty eye-opening.
My contact number's on the slide, and I'm on LinkedIn, and I've got a website. So if anybody has any questions that they want to direct to me privately, feel free.
Appreciate it. Well, I hope everybody has a great afternoon and the rest of the week. And anybody coming to the Washington Summit with the PACE, formerly ATA, let us know. We'll be out there as well.
Thank you, Ryan. Thank you all.
Have a great one.
Have a nice day.